come to us because they feel that something has been missed or something has gone wrong with their medical care. Examples of this might be a late diagnosis of a condition or a disease, an unexplained or unexpected death, problems with or arising from surgery, or perhaps a patient feels that a doctor or a surgeon has gone beyond the level of consent that they have given. On the odd occasion, people might be advised to seek legal advice by their medical practitioner. In some circumstances, there may be a complaint response or a serious incident investigation, which alerts the patient that something has gone wrong with their treatment. We offer free initial advice over the telephone or in person. We gather as much information as we can from the client, take a detailed history of their background and what they feel has gone wrong, and from that we give them some initial advice about whether we think a claim is worth investigating further.
There is a two-part test to proving negligence, and it's important to stress that you need to satisfy both parts of the test. First, you must be able to show that mistakes were made which in law amount to negligence. This essentially means that the care received fell below the standard that is expected of a reasonable medical practitioner in similar circumstances. You must then go on to show how that negligent treatment has made the situation for that person worse. This could either mean that they have made a pre-existing condition worse or caused them an injury that they otherwise would have avoided. We do sometimes find that clients have received negligent treatment, but if this has not caused them an injury or made their condition worse, in those circumstances we can't pursue a claim for them.
We use our knowledge and our expertise to spot the cases which we feel have a reasonable prospect of succeeding. However, in order to prove a negligence claim, you do need expert evidence. Each case is different, so whilst one case might require only one expert, others may need several. The type of expert also varies. It's important that you have an expert who is specialist in the particular area of medicine that you're concerned with. For example, if the concern relates to treatment provided by a GP, it is important that you have a GP expert assess whether or not that care has been to the required standard.
The process starts with an informal discussion so that we can firstly get to know the client, but also to take a detailed history from them. If we think there's a claim to be investigated, then we need to sort out funding. We are finding that more and more people have what's called legal expenses insurance, and they may be able to use this to fund their claim. If the person doesn't have such insurance, they can still fund the claim by way of a conditional fee agreement, and these are more commonly known as no-win, no-fee agreements. Once funding is in place, we obtain a full copy of our client's medical records. We then carry out a detailed review so that we can update the client on what we believe needs to be investigated. We use our expertise and our experience of similar cases in order to determine which experts need to be instructed and what issues we need to discuss with them.
The relevant medical expert will be instructed to review the medical records and any witness statements that we have obtained. The expert will prepare a report dealing firstly with whether or not there has been negligence, and secondly, whether that negligence has caused or materially contributed to the client's injury. It is possible that we might need more than one expert to establish the different parts of the test for negligence. If the expert or experts support the claim, then we will put forward a letter of claim to the other side. In that letter, we will set out the allegations of negligence we are making and how this has caused injury to the client. The other side will then have a period of 4 months to investigate themselves and provide their letter of response. They will either admit or deny the claim, but they must provide their reasons. Sometimes it's possible to enter into settlement negotiations at that stage. In other cases, it might be necessary to start the formal court process. We will do that if the experts support the claim going forwards. That will involve entering into a court timetable, which has a trial as the end result. However, very few cases end up at trial. Most will settle somewhere along the court timetable.
Whilst we look at the liability side of things first, once we think there is a claim to be investigated, at this stage we can start to look at the potential value of that claim. The way we value a claim is by looking at how that negligence has specifically affected that person and their life. Things that we look at specifically are whether they have any care and support needs, whether they need any treatment, and also whether they may need things like aids and equipment or accommodation adaptations. Valuing a claim often involves additional experts, and the client will normally need to go and see at least one of those experts, and that's so that the expert can explain exactly how the negligence has affected that person specifically. Our main objective is to ensure that we have thoroughly investigated the claim and achieve the best possible outcome for the client.